so glad you're here, and I want to thank you for stopping by. Now, I have a general trio checklist for the first year students' law exam, and it's for general subjects for California baby bar. And I basically made 3 main lists, and I've been refining the list a bit. And I did a video going over a friend's practice exam. They are trying to practice for the baby bar. And I went through it, and I'm going to do it over, okay? So basically, it was a contracts question, and I've reviewed it, and I think I could be a little bit more succinct, so I'm locking that up, and then I'm going to replace it with this. So basically, she's going to be doing these student exams. If you want to follow along, you're welcome to. And what you can do is go to this site where I have forms, and I probably should put the memorization attack sheet up that I'm using, but I'm still tweaking it and refining it. And I noticed I didn't put warranties for contracts in here enough, and I had to go up and go into the torts sections, but really for contract law you can put a separate section in there for the warranties. So this issue came up in this contract question, which I'm going to go over in a minute, but first I want to make it so that you can go and do a practice exam. And basically the California Bar releases other bar questions, and you can do practices. They have multiple, the National Conference of Bar Examiners also has released MBE questions and released MEEs, which are essays. Now, what happens is the California Bar releases their old exams, and then if you download them and then re-upload them. So basically here is where you can get this 2008. That's what I'm going to be reviewing, and the link is below in the description box, and you can get that off of there. Okay, so what is it? It's this 2008 exam. It's question number 1. Now, question number 1 is a contract law question. That's the first question they're posed with, and we're going to go over quickly. Now, when you're practicing, do not get discouraged if you're looking at the model answers and you're like, oh my gosh, look at how they wrote it and look at how I wrote it. So you need to practice to get your timing down to get this written in the time allotted, which is going to be about an hour for each one. They're going to give you, if you're taking it online, they give you an hour for the test, they give you 15 minutes off, then you have to get back in front of the camera again. And so it's 1 hour each. Now, if you were at a brick and mortar location, they would just do it 4 hours straight. You wouldn't get a break. So people that need to take a break to use the restroom actually are getting an advantage if they're doing it online, because they're building in a 15-minute break between each exam. Now, again, I'm doing this particular one over, and we're going to go ahead and look at what my friend wrote and then the model answer, and we're going to read it. So typically, I'm going to repeat this because I'm doing it over, but I'm going to do it a little bit more quickly. So you have a fact pattern here. You have to get in, you have to get out, but you got to fill in the details. So when you look at this, just kind of skim it and then go straight to the question. The 2 questions are, under what theory or theories may Paula be successful in a breach of contract? Let's pretend I'm doing it right now. I would just take these 2, copy them, and then I would put it below the, right? Then I'd maybe underline it, because this is what they're asking. And then I would go look who's, okay, Paula is going to be suing against Bert. So it's Paula versus Bert, right? Okay, we're going to look at what my friend wrote, and then let me fix that. Okay, so actually maybe I should put this in red. Okay, so this is what I wrote. This is not what they wrote. Okay, so let's read the fact pattern real quick. Abby and Paula entered into a valid contract. Boom, right there. It says there's a valid contract. What does that mean? It means you do not have to get into offer, acceptance, consideration, concurrent meeting of the minds. So all you have to say is, okay, there's a contract that's valid between Abby and Paula. But if you look at the question, it's asking you about Paula and Bert. So immediately a light bulb's going to go off in your head. Is there a third party beneficiary? Is this a let's read the fact pattern and find out what's going on, okay, before we jump to any conclusions. So what you do immediately also, if you don't have your checklist totally memorized, or if you're really nervous because it's like the first question, you go in your little box, and in the corner there will be, this is for online exams. If you were brick and mortar, they just let you write on a scratch paper. You write out your exam outline trigger checklist, just the initials, not the whole thing. Let's forgive everyone today because love rules, that's the law formation, so it's, you just put that in there. You might want to put IRAC also in there. Now remember, IRAC is issue, rule, analysis, conclusion. Your issue needs to have the rule of law named in it, and then a definition of the rule, and then an analysis. So you want to synthesize everything together, and then you want a conclusion. You want to break apart the facts. So remind yourself you're following a pattern with each section. So we're already reading here that Abby and Paula had a valid contract. Abby agreed to buy, and Paula agreed to sell 1.5 million printing press for Abby's business. Now, Abby made a $500,000 payment to Paula at the time of the sale and agreed to make the final payment of $1 million in 6 months. Okay? Now, we already have elements of a contract, but what do you think is the governing law? Remember, let's forgive everyone, law. Okay? We already know they formed a contract, but still there might be some issues. We'll see. We'll go further in the fact pattern. So, okay, what law do you think applies? We have a printing press for a business. Are they merchants? Right? That's another question. So, what do you think? Okay, so let's move to the next paragraph. And just prior to the date, the final payment was due. So let me just say one thing. What is this? Do you know? It is UCC. It's movable goods. They appear to both be merchants. So you write below the Paula versus Bert, you write UCC, which is the law, and then you write the definition of why UCC applies, and then you write why it applies. You show your work, and then you write a conclusion. This could be a couple of sentences. It doesn't have to be that much. Now let's see what the friend wrote. She wrote UCC, governing law, UCC, common law, UCC governs movable goods. The fact pattern shows that Abby, a business owner, had a purchase contract with Paula for a business for 1 million because the good is movable and the contract is for a sale of goods. Very good. Now she did not put in there that they're merchants. Let's go take a look at this model answer in here that was a passing bar answer. Up here they have for question 1 they have the first call of the question here, and then they have the issues, and then they have second call of the question. So they have done the same thing that I recommend, and that is to just write the 2 calls of questions and then fill in. She also did this. She wrote Paula versus Bert, and then she wrote up here, she said she finished in less than an hour. I think she said it took her 45 minutes. You got to get your typing speed up, you know, if you're going to do. But so she put valid contract, and that's true. It's a valid contract. Now, I told her very good, but actually I started thinking about it, and I reviewed one of the Emerson Bar Review videos, and he said if you look in the fact pattern and you see that they say they had a valid contract, you typically do not have to go over that. So I'm going to go with what she said here. She says right here in the first paragraph, Abby and Paula entered into a valid contract. This removes the formation issues of offer acceptance and consideration from issue. So it's not an issue, it's a moot point. A moot point. So then she writes, or he, this is a contract for goods. UCC applies. A good is personal property that's movable at the time of the sale. Here the property is 1.5 million printing press, which is movable to Abby's place and therefore is a good. So this person they just wrote like an introductory paragraph. It's a little harder on the eye for an exam grader. Now over here, this was a passing answer. I'm taking it section by section. And then, so here in this other one, they wrote Paula versus Bert, and they put UCC at the very top. And then they put goods, and then they put merchants, and then they put offer and acceptance and consideration. Now, is that necessary? The other person passed, and they didn't put that in. They said it's a non-issue. I would not waste valuable time on something that's not an issue. But the other bar exam grader Emerson, if you go look at his videos, which I will put the link to them below, I have Emerson Bar Review videos. They're from 2000. They go up to 2007, so they're old, dated videos. But I'm going to make a big playlist of all of them. But I have little playlists by subject. So I have the link to the contracts playlist of his. And if you watch it, in one of them he says, you do not have to write in offer acceptance consideration when they tell you it's a valid contract, which this particular one does. Okay? So let's take a look down here. If you want to pass the baby bar. Now, every state is different. Emerson specialized in California, and it looks like, but you know, are they going to take points off if you put in their non-issues? Probably not. Alright, so then we go under what theory or theories may Paula be successful in her breach. And if you're grasping for definitions and so on, go look, you know, if you're doing practice ones, you can go look at your, here, let me close this. Go look at your outline. Now I'm going to fill this outline in a little bit more that I have. But I did create some videos of the outline, me saying the outline out loud if you want to kind of just doze off and kind of like, you know, go through the rote memorization. But I am going to do a new video of the contract section over, and then I'm going to close up the old one because I'm going to add in the different type of warranties. Okay, so we have our UCC, Paula versus Bert, and then the merchants, right? So in both of these, she put that right up here, she put UCC applies. Now this is a little bit harder on the examiner because she didn't put in here UCC and break it apart. The other person did. So they'll put up sample passing ones. They won't tell you what they got. Maybe they got a B, but they usually pick some of the better sample ones. So right off, UCC, that's your governing law, and then goods and merchants. And over here, she is saying all this, but I'll tell you, these exam graders don't make that much money. And they see right over here, they have merchants in their description. If you make it easier on the examiner, the grader, and it's popped out, you know, they have a model answer next to them, they're going to have to read this whole thing. If you just have the header in there, and then the definition, and then the analysis, and then the conclusion, issue is up here, merchants. You don't have to write a full sentence, are they merchants? Just write merchants. You could save valuable time that way. If you are writing something for a class or you're in a law class, ask your professor what they prefer. It's not the same thing exactly as the bar. So you can go through this, and then you write them in the exact order that they're being asked and the exact order that they follow in here. So they're merchants, right? They don't come out and say they're merchants, but you can see that they're merchants. Paula sells printing presses. That's what she does, and she deals in the kind of goods. Let's take this off. Well, anyway, so let's read the next one. Just prior to the date the final payment was due, Abby sold her business, including the press, to Bert. As part of the sale, Bert agreed with Abby to pay Paula $1 million due to her. Abby represented in the purchase agreement between Abby and Bert that all the business equipment was in working order, although she knew that the press never functioned as it was intended to. In fact, Abby had previously requested of Paula that she repair or replace the press, but Paula refused to. After Bert bought the business, he discovered the problem with the press. He told Paula that he would not pay her $1 million due until she repaired or replaced the press. Paula immediately filed a breach of contract lawsuit against Bert for the outstanding $1 million balance. Bert denies any obligation to pay Paula the $1 million on the basis that he had never entered into any contract with Paula. In addition, Bert asserts two other defenses. First, that the print, okay, so you've got his defenses spelled out right here. And normally, I'm not sure with the online one. I can go ask some of my friends. I know some people that took the online baby bar. I'll ask them if they're allowed to mark up the fact pattern. They said it was a pain in the neck scrolling back and forth. Okay, so he has two other defenses here. The printing press is defective and unsuitable for its intended purpose. And second, that Abby material misrepresented. Okay, so under what theory or theories may Paula be successful in her breach of action? So now that you've cleared up that they're merchants, and that I just put rule or definition. So IREC, this is the I issue, rule, you tell the rule of law, and then you do an analysis, and then you do a conclusion. This is a conclusion here. I actually took an ABA accredited paralegal writing class, writing 1 and writing 2, and I've got experience with the writing. I can write these pretty well. This is the MBE was the one that I always had the problems with. Okay, so let's see. I suggested that they use different formatting, and just wrote some notes to them, and they said they're going to redo it, but I discussed it again, and then I went over the Emerson Bar review stuff just to refresh my memory, and you can do the same thing. And in there he advises on the California Bar. It was prior to 2007. He retired and donated his videos to the public. So that's why those videos don't have any ads on them. And I've got the link below. You can look at it if you want to spend a little more time going over the rule of law, and then you can compare and memorize your list. So after Bert bought the business, he discovered the problem with the press, yada yada. Okay, we read this already. Bert denies any obligation to pay Paula. Right. Okay, so we went over the rule of law and how it's going to be done, and so the best way to write it, the model answer, is to do the issue analysis and rule conclusion for each one. Now I'm going to take this out. Don't waste valuable time on non-issues. Really. You're being timed. She finished it in 45 minutes, but you've got to get your timing down on these. This other person, they did pass putting down these issues that were not issues. Okay, and that's because they probably didn't know. You don't have to do that. That's what Emerson said, and I'm going to go with what Emerson said. He's been doing bar review. I think he did bar review classes for like 30 years, and then he retired. I can't get any of the books or anything like that for it. He had books he says in there to refer to. But what I have done is I've tried to pull down some of the old videos that he'll say what he'll say this is a 2001 bar question. If you have a bank of or some old questions to review, you can use it. They recycle some of these questions, by the way. So, and actually some of the MEE type of questions might wind up in an MBE question, but you have to answer A, B, C, or D, or a multiple choice question. So it just gets your mind to do the mental gymnastics, to organize it the way the examiners want to see it, and show them that you have the law memorized. It's not just a fluke you pick the right answer on the multiple choice. So you're writing it out. You're going to do it in a lawyer-like fashion. So under what theory? Okay, so what theory? First, right off the bat, she writes, or he, Paula is a third-party beneficiary under contract between Abby and Bert, discussed below. She may sue Bert for breach under her rights as a third party. Very good. Okay, she also has the right to demand assurance of payment from Bert as the delegatee of Abby's duty. Now, this is very well written. The problem is that a lot of these examiners don't want to read the whole thing. They want to kind of scan it. They might have a stack of over 100 of them to look at. and they want to give it a grade, but they're only paid like $3 or $4 or something per exam, and they're lawyers. So I'm just saying that the graders want to get through their stack and get paid. And I honestly think that, back in, when was this, 2008? I don't know, maybe, I don't know. I feel like some people might not have as much patience, and they're going to scan it. So, and if they do, and they get something like this passed, because it said UCC, yes, that's UCC. Goods, yes, that's goods. It's up here, they got to spend more time on it and slow down. So, I mean, I would think, even though that's really well written, it's not considerate of the examiner. And yes, it was a very good model answer, good enough to get published. So whoever read it, they said, hey, this person knows what they're talking about. Maybe they got like a 90. I don't know. I didn't read through the whole thing. We can go through it one at a time. So, this person put assignment. They did not have to put valid contract. They didn't have to do the offer acceptance consideration. Normally, maybe this person just went through it and was like, didn't even read that part because it's not an issue, and jumped ahead when they're grading it. I'm not a grader, I don't know, but that's what I'm thinking. Okay, so valid contract breach, third-party assignment. Now, it should not say third-party assignment. Wrong label. It should just say assignment, period. Okay? And it's an assignment of a contract. Okay? So what do? You go to your definition. An assignment is when a party to a contract intentionally releases himself or herself from any rights under the contract and instead creates these rights under a third party. Privity is not required, though the rights must be assignable and vested in the third party. So this particular one, where they added in some extra rules that really weren't necessary, they've got their information correct. And they're saying the facts provide that as part of the sale, Bert agreed with Abby to pay Paula the $1 million due her. So he did do that, not considering the effect of the work, with which could still keep Abby liable. Abby may have successfully assigned her agreement with Paula to Bert. Since privity is not required, and since rights are not too personal or prohibited by the contract, thus it's assignable. So you kind of, go over that. You spell it out. Thus, Abby assigned the rights. I'll say the sentences don't flow that great. The style's okay. This is a passing one. In here, this one is needs work, and so I asked her to redo it, and we talked about it some more, and I just double checked, and I thought I'd go over these. So I guess they could write a sentence here: are the rights assignable? Assignment, I think what this person did is write assignment. I like that. Now this other person wrote, are they assignable? And they didn't have to write that, I think. Or did they? Delegation. Was the duty delegatable? Really, I think what the examiner, it was a delegated duty, but these are delegation of a duty, novation, defenses. you know, I like this other guy just getting, or girl getting to the assignment. Now, like I said, you can put in non-issues or details that they're not looking for, but it would waste valuable time. So she puts third-party beneficiary up here, or he, and then writes a definition and puts in front of it definition. She didn't have to put definition there. You can just write a third-party beneficiary is one who receives rights or the benefit through a contract between two or more other parties who, while forming the contract, intended to benefit the third party. See, now this, the definition that you memorize does not have to be exact wording, but it has to include the important elements. And it doesn't have to be perfect. These are passing ones that are not perfect, but they're close enough. And let's take a look at the other list. Hang on. I'm trying to find my list here. Alright. Here it is, I think. Alright, so here we go through these different areas. And one of the things I was doing is I was looking at this outline and I was like, I put in warranties, but I didn't really do the warranty of merchantability. And really it falls in both the contracts and the torts. But there should be a section, because actually I reviewed the outline and I reviewed the, so this is the one I like to use. You can use whatever you want. But so if you go through here, so with the formation, with this particular one, it wasn't necessary to put this in and ask, do you have a contract? Okay, it's not at issue. But these ones that pass, they don't have to be totally perfect, but how about you try to make that, do your best and try to make it as perfect as you can, and know what the examiners are looking for, and for gosh sakes, try to make it easy on the examiner so they don't have to read through paragraph after paragraph. They can just go boom, boom, boom. They have a checklist or a model answer next to them, and they're looking for certain issues. And if you're missing 5 issues and you're filling it with non-issues, I don't know how exactly they do it, but I think that they're looking for, I've been a teacher, I've worked grading. We would make sure, and what percentage is missing? Is 30% missing? Okay, well, you've got 70% that's passing for the bar. And of course they do scale these exams when they test them. So you go through here and you memorize your checklist, and so this is the definition I like to memorize: one who regularly deals in this type of good, or one who holds themselves out as having a special skill or knowledge regarding this type of good pertaining to the contract. Now, here each of them had a slightly different rule written down. Close enough, just make sure it's got each as much as you can, and sometimes a person will, I've seen some where they didn't fill in what the rule was, but they labeled the rule on the top, and then they did the analysis and the conclusion, and that was good enough for the person that examined it. So, each section's going to be IREC'd. If you are running out of time, maybe you might be able to do that. So Now, if you wanted to put Lawrence versus Fox about the privity in there, why? See, this other one did not put Lawrence versus Fox, but the one that was really good, but it didn't break it apart or make it easy on the grader, where is that? That had the Lawrence versus Fox in it. Gosh darn it. This is kind of hard to work through these three. Okay. I'm looking at, see right here, she's got, or he's got Lawrence versus Fox. So these are Lawrence versus Fox. If you don't remember this case, it's one of the early classic seminal cases where privity became a thing. And this set the precedent that's followed ever since, that you don't have to be directly in the contract itself or have privity. Prior to this, to have standing to sue, you had to have privity. But with Lawrence versus Fox in 1859, that's before the Civil War was over in New York, it created a right for a third party to sue without privity. And I put a brief of the case just to trigger my memory. Also, I put Restatement Second of Contracts 302 because I looked up the rule of law just to double check. So you can write, if as soon as I hear third party beneficiary, it triggers me Lawrence versus Fox. That probably impresses. If you can cite some cases in there and say privity, Lawrence versus Fox, you don't have to do that. This other person just put in third party beneficiary. They stated they didn't have to have privity. Privity is not required. They didn't say why. They didn't say Lawrence versus Fox. That's okay. That passes. But if a grader is going through it and they're seeing you, everything they see you write is like spot on, and they're kind of scanning through it, they're going to be like, okay, this person knows the rule of law. Even if they by mistake threw in stuff that's not an issue, maybe they don't know how to take the bar exam right, but so just assume when you look at the fact patterns that the facts that are in the pattern are just what they say. Valid contract, right? Now, if they said they dispute there's a valid contract because it was common law and it's missing time, maybe you might want to terms that would be questions about the terms of the contract, right? So, let's see. So the question we answered is Paula versus Bert. You're breaking it apart. Again, a delegation occurs when duties under a valid contract are passed over to a third party. That's right. This is what must be considered. So it was Bert did assume the duty. He assumed that he was the effect of the delegation. The duty is delegable and it has been assumed. Novation, you've got these different things. Novation, you've got counter offer, these kind of other things that come up in contracts. I don't really think she needed to put that in there, or he. I feel like what this other person put in there, I mean, while it is true, I don't think that's what the examiners were looking for. They do want to know the rule of law, but I think if they had a model answer, it probably wouldn't even have that in there. It would have warranty of merchantability, not just warranty. Now this person, this other person is putting in stuff they don't need to put in. if you look in your contract, it's an implied warranty. Express is when it's explicitly stated in the contract. It wasn't stated. And then it's warranty of fitness. Now, if you look over here, I actually put definitions below the contract part, but I started to, I'm going to finish tweaking it and then redo it. These are defenses, but so basically there's a condition of a contract as well. If you think about it, as a condition, it should be working in order. Well, that's usually with a service contract, and then it's implied, right? So good faith, cooperation, and work performed in a workmanlike manner are judged by a reasonable person. So, you know, condition precedent, concurrent, frustration of purpose. I'm just kind of going over the list. Actually, that's not really completely... but see, novation, a new party is substituted into a contract with the agreement of all parties involved, extinguishing the rights and duties of a substituted party. Well, all parties did not agree to this. So is that an issue? You know, that's why I said I don't think that's an issue, because I think what happened was exactly what the fact pattern says, which is that, well, we can go look at it again. If you look at the fact pattern, it's going to say that she sold her business and everything to him. He didn't, there was no privity, okay? Basically, that there would be privity if there was novation. But she put in Lawrence versus Fox, like she understood privity, or he. Okay, so I started to fill this out down here. I put warranties, and then I put the several that could be violated, and I put express warranty is explicitly stated under UCC. An express warranty is created by any of the following: an affirmation of fact or promise made by the seller to the buyer relating to the goods, description of goods, or a sample model which became part of the basis for the bargain. Now, implied warranty of merchantability warrants that good will be fit for ordinary purposes for which the goods are used. And then there's the warranty of fitness for a particular purpose only. And I didn't finish it up, but basically I'm tweaking this as I go, because for some reason I had put it just in the torts, and I think it belongs in both places. So, you know, just like with criminal law and torts, you're going to have overlap, assault, battery, but the thing is you're going to have a slightly different nuanced meaning to it. So, third-party beneficiary, see that? Privity. This is good, you know. It's good, but it's work to read it, and it's definitely a passing one. They understand the law, not, you know, did they understand the whole question exactly? Did this person miss that it said right up there there's a valid contract, or maybe they just didn't know you don't need to do that. So I was a bit remiss, and I was thinking you needed to do that, and then I went back and watched that bar review thing, and it was like, no, you don't need to. So that's what I would do. I would answer third-party beneficiary, what they are. Paula's asserting this. privity, and this person, she broke it apart with his defenses. And it says in here, what is the likelihood that the additional defenses asserted Bert will prevail? Now, let's go look at the fact pattern real quick to see what the question is again. I mean, what he said. It says, in addition, so they're asking about the two other defenses. The printing press is defective and unsuitable, and second, Abby material misrepresented the condition. Now, let's take a look at these model answers, what they put at the very bottom there. Misrepresentation, they covered that one. And warranty. Alright. So he put express, implied, yeah, we were just looking at this, and implied warranty of fitness. Now, this is okay. And this express doesn't need to be in here. It's a non-issue. It just should say implied warranty. And if they want to put implied warranty of merchantability and fitness and add that in, go ahead. But with the express, you don't have to do express, because express is like when it's in the contract. It wasn't in the contract. So basically, and they say that in this case the facts don't support that. Now let's see what okay, so these are the additional defenses here, each discussed in each turn. So she's writing a little paragraph for he on the very top, which is fine. Bert has two significant defenses he may raise. The printing press is defective and unsuitable for its intended purpose, and that Abby misrepresented the condition of the press, and she entered in the contrast. Each will be discussed in turn. So she quickly writes that in detail. She doesn't have to scroll all the way back up. She's got it right in front of her. But the defective press, Bert, by stepping in the shoes of Abby, may assert all the defenses against Paula that Abby could assert. Here, Abby had informed Paula previously that the press never functioned as it intended to. Yada yada, perfect tender rule. Here, Abby informed that Paula that it was defective. Yada yada. Bert may assert the same defense and is likely to prevail. So remember, the question is, will they prevail? Are they likely to prevail? Let's see if I can do that. And misrepresentation. Paula only has an action against Bert if there's a valid contract. So, okay, they may have a model answer that has what they're looking for was warranty. This reader is going to have to look and read the actual damn paragraph. Excuse my French. That's fine if you want to do that, but I'm telling you, an exam grader might be trying to get through them and might not want to read through it and might miss that you put implied warranty in there. I don't know, you know, I have no idea. But so here they have the warranty right off the bat, and this, and they put a space between it, and it kind of jumps out at you. And again, this is A. Both of these are passing. We do not know the grade. And so if you were a grader, you could step in the shoes of the grader. You're not getting paid what you're worth. You're an attorney. And you don't work for any bar review place or anything like that. So that's what you need to do, the issue, rule, analysis, conclusion, and go through it line by line. Get it done in the hour. So this person put the 3 defenses. He never entered in a contract with Paula. They didn't put that in theirs, and they passed. It said, what's the likelihood that the additional defenses, this is the additional defenses. So they're already saying that this particular one is not an issue. Now, did he get points taken off for putting a non-issue in there? No. Or maybe he did, I don't know, or she. So we can see that that it's going to take some practice. Compare the practice answers to the model answers. If you can get a second set of eyes, somebody that knows what they're doing, to give you their critique, and continue to work and rework them, and look at these other ones that have already passed, you should be fine. It just takes practice, understanding what the examiners are looking for, and letting them know what you know, and that you can answer like a lawyer, analyze it, synthesize it, and show your work. So these lists are below. Thanks for listening. Take care. Have a great rest of your day.